Today, I'll be discussing with you the fourth preambular objective, that is fraternity. Now, you see that in the Constitution, the words which are written before fraternity, that speaks of to promote among them all fraternity, that is assuring the dignity of the individual. So fraternity and dignity, these two words, these are joined together, and that is of the individual. So first of all, what do we mean by the fraternity? This becomes important. What do we mean by the fraternity? And if we see the definition given by Barker, what he calls about this fraternity, so he says that this fraternity as a principle of cooperation. Cooperation, that means it includes a lot of rights to share, to enjoy the common resources, and to avail the services of the nation. We see that these services like education, police, health, and other public utility services. For example, this public transportation. So these are the services of the nation which brings the fraternity in action. And this is a feeling of common brotherhood which gives rise to the fellow feeling that we must help each other, that together we can live a better life. And this is how we can mean by this fraternity, which is a common brotherhood or a commonness, or the common sharing of the things, common sharing of the resources, common sharing of the public services, public utility services as such. And it is like something that as the sons of the same soil, तो कहते हैं मातृभूमि के लिए हम सबको एक जैसा करना चाहिए. So this is similar things like that, we being the son of that similar soil, the nation, we should share our things, we should keep the services of the nation for sharing to all of us, and all the citizens are to be considered as brothers. And you must be remembering one of the slogan, which was very, important at once time. And now also we are listening these type of the things that Hindu, Muslim, Sikh, Isai aapas mein sab bhai bhai. So why we need to say these type of the things? This is just in order to enhance that common brotherhood, in order to enhance the fraternity in the nation as a whole. So we say that this fraternity means that they must stay with each other. We all, the citizens of the country, they must stay with each other in every situation. As brothers, as sisters, they all should come together. And if they stand and fall together, then we will find that there is a concept of the fraternity. So the simple term or the simple meaning of the fraternity can be the cooperation, the principle of cooperation. Then B. Shiva Rao, he was the constitutional advisor, and he, in his framing of the Indian Constitution, has written that regarding fraternity, which is the fourth objective preamble of the preamble, and that why it was added in the draft by the drafting committee in the Constitution. So he wrote that the committee felt the need of fraternal concord, the fraternal harmony, the fraternal unity, and goodwill in India that was never felt before as it was at that time when the Constitution was being framed. Because we all know that how India was divided at that time, and how it was required that more and more commonhood, more and more cooperation, more and more brotherhood was required. And that's why this was the idea, this was the philosophy, that the constitution makers, they were having this particular aim, that this should be emphasized in the constitution. And therefore we see that the special reference has been made in the preamble to the constitution of this word fraternity. As we all know that this has come from the French Revolution. So we have incorporated in our constitution this term fraternity. Then a democratic system, we see that in a democratic system, we find that it would function only in a very healthy manner, in a proper manner, if there is the spirit of common brotherhood, if there is a spirit of the commonness, or if there is a spirit of the sharing of the things, or in other words, we can say if there is a feeling of the oneness among all the people in the nation, then only we find that democratic system can run properly. So we know that India is a land of diversity, as I told you yesterday also. And so here it is more and more needed that a spirit of unity or the sense of the belongingness of the nation, that was very much required. So we can say that this is a term fraternity which cannot be found, or which is something which is abstract term. But if we find some of the provisions in the constitution, then we'll find that yes, through these provisions, the fraternity can be ensured, and that has been assured by the constitution makers in the Constitution of India. So that feeling of oneness among the people of nation, that was very important, and that has been ensured by providing or by ensuring the equal rights to all the persons through which the fraternity can be promoted. Dr. Ambedkar, he said about the fraternity that it is the principle which gives the unity and solidarity to social life. Fraternity is something which gives the unity and solidarity to the social life. And this is a feeling which protect the unity of the India. Unity from what? Unity against the external attacks or disintegration type of the things will not be there if all the citizens of the country will be united. So this is something which was important, and this you see that the promise of fraternity as a means of improving the relations between different castes and different religions, different communities, that is all being reflected in the provisions of the constitution, that particularly equality is very important in that respect. So we find that what Dr. Ambedkar speaks about the fraternity to mean there is a relation between the people, the relation between various religions, the relation of the society as a whole, that will promote the fraternity. So we find that besides preamble, the common citizenship or the single citizenship is one of the example of this fraternity that you see given under Article 5 of the Constitution. Because we in India have a single citizenship, and that citizenship is for the nation, for the country. It is not for the states like America, there is a dual citizenship. In India, we have a single citizenship, and that promotes the idea of fraternity. Besides Article 5, then you see that there is a provision in Article 301, that is free trade and commerce in the entire territory, throughout the territory of the nation. And that is another example of unity and fraternity in the constitution provisions. Then to promote this fraternity, we find that of course the provisions in part 3rd of the constitution, they are also designed to promote the fraternity, that the rights of the citizens in Article 19, that is to move freely throughout the territory of India. And there is no distinction, there is no discrimination. However, certain restrictions, reasonable restrictions are there. But otherwise, every citizen has a right to freely move throughout the territory of India. He can go at any place, any state, any district, wherever he wants to go, can go. And this improves and this promotes the fraternity. Similarly, every citizen has a right to reside in anywhere in the country, and to settle in any part of the country of the India. And then at the same time, citizens have the right to practice any profession or to carry on any of the occupation or trade under Article 19. So all these provisions promotes fraternities. These provisions promote the oneness in the nation. And you see that prior to 44th Amendment Act, this to acquire and hold or to dispose of the property was also there, though it has been deleted by 44th Amendment. So these were the rights under Article 19. Then besides this fundamental rights, we see that part 4A, though it has been added by 42nd Amendment, but it also shows those principles which also promotes the fraternity. And particularly if you see that Article 51 Clause A.E, which is one of the fundamental duties. So there, the duty of every citizen is just to promote the harmony and the spirit of common brotherhood. And this common brotherhood between whom? That is between the citizens, amongst the people of country. They may be belonging to any religion, they may have any language, they may be from any of the region of the country, there may be sectional diversities, but what is required by this fundamental duty, that is they have to promote the harmony and the spirit of the common brotherhood. Then we see that in the context of this fraternity, we see that the constitution that goes beyond national boundaries also. It is not only that this concept of the fraternity is confined in the constitution concerning national things, but it has gone beyond the national boundaries. And we see that there is also an international aspect of fraternity in the constitution itself, which takes us to the concept of universal brotherhood. You may be knowing that the ancient Indian ideal of this Vasudhaiva Kutumbakam, that is the entire world being one family, that is also promoting the idea of the this fraternity or the common brotherhood. And this provision of this Vasudhaiva Kutumbakam or the world being one family, you can find in Article 51 of the Constitution. Under the directive principles of the Constitution, you find that Article 51, which speaks of the international treaties and international things. And on that basis, we see that the entire world is being one family, and the fraternity is tried to be enforced and promoted by this provision also. As you know that H.M. Seervai, he has always written something in a critical manner. Similarly, for fraternity, his views and his arguments were also, to some, we can say, extent, were of a different opinion. And when he argued that preamble in this fraternity in the preamble, that is just fair and just executive can promote the idea of fraternity in a better way than the constitutional mandate. That he was of the opinion that it should not be in the constitution preamble. Fraternity should not be there in the constitution preamble, because this could be more properly, implemented through the executive order and not by any constitutional mandate. And he further argues that this concept of fraternity is a moral and political ideal. And the moral ideal or this political ideal need not be the part of the constitution. So this ideal of the preamble, he says that this is ambiguous, this is something vague which cannot be implemented properly. And he was of the opinion that without the proper understanding of what these ideals are, they are useless for any constitutional scheme, because he was of the opinion that these principles are of no values in the constitution. And he supported his argument by saying that there are provisions in the constitution which are against fraternity. For example, he has given the example like the division of states on linguistic lines, that on the basis of language there are certain divisions and partitions of the state. That is not a case which is promoting for the fraternity. Similarly, the provisions in the constitution which are relating to the language, that is also affecting the fraternity, or that is militating the fraternity. So if these type of the provisions are the part of the constitution, then how it can be the preambular objective? But we see that this preambular objective, which was put in the preamble to the constitution, which was said to be one of the need of that time when the constitution was being framed, the judiciary has very well taken this concept or the idea of fraternity. And you see that there are various cases in which the judiciary has accepted this fraternity to an extent as a basic structure of the constitution. And you see that the first and most extensive discussion on fraternity that took place in the Supreme Court, that was the case of Indira Sahani versus Union of India. It was of 1992, also known as the Mandal Commission case. And you may be knowing the facts of that case, how this 27% reservation has been, recommended by the Mandal Commission for the other backward class in the society. And when this case was being heard in the Supreme Court, then Supreme Court has emphasized that the words fraternity, that is assuring the dignity of the individual, that have a special relevance in the Indian context. In India, that has a special relevance because of the social backwardness of certain sections in the society, which were prevalent at that time in India. So the Supreme Court was of the opinion that certain sections of the society or the community who were not having the similar facilities, they were not having the similar status in the society, or who have been looked down by the society as at large. So this idea of fraternity was used by the court to justify the constitutional practice of reservation for the backward classes, and to bring about the progress of the persons who were marginalized in the society, that is the marginalized section in the society. So here in this case, what the Supreme Court has done is that this idea of fraternity has related with the reservation, and the Supreme Court was of the opinion that the constitutional practice of reservation for the backward classes, that is important in order to bring about the progress of the marginalized sections of the society. Now, in this case, one Justice Thoman, he dissented of this judgment, but the majority of the judges, they have related their ideal of the fraternity, and this fraternity find place in the judgments of the majority judgment, where they use this fraternity in the context of this reservation. And it is very interesting also that as the justification of the affirmative action, they said that this is not based on any conventional theory of substantive equality, or what we say is the equality, but it is the assurance of fraternity that is seen to be as a means to achieve the equality. So for the court in this case, they were of the opinion that fraternity is important to achieve the equality. If there would not be fraternity, equality cannot be achieved. And equality, that is talking about the theory of the substantive equality in that particular case. And this was the opinion in this Indira Sahani versus Union of India, that is Mandal Commission. Then regarding privy purse, you may be knowing as to there was the provision for the privy purse for the princely states earlier. Then in this Raghunath Rao Ganpat Rao case of 1993, Justice Pandian of the Supreme Court, he used this principle of fraternity, and he rejected the argument that in the princely states which were there in the country, so they cannot form a separate class under the constitution, and they cannot have any special privileges. Being the members from the princely states, they cannot enjoy any special privilege because the constitution speaks for the equality. The constitution speaks for the fraternity, and in that fraternity, until and unless the equality would be there, then it cannot work for, it cannot promote for the fraternity. So it is important that these erstwhile states which speaks for the privy purse, that needs to be abolished. So the Supreme Court in this case abolished the privy purse, and the court has also paid some, we can say, the attention towards the sentiments of Dr. Ambedkar when he was of the opinion that inclusion of fraternity within the constitutional provision is very important, because in a country like India, where there are so many disruptive forces like regionalism is there, communalism is there, linguism is there. So it is necessary to emphasize or to re-emphasize that the unity and integrity of the nation can be preserved. and this could be done only by the spirit of brotherhood. So India has one citizenship, and every citizen should feel that he is Indian first. So until and unless this thinking would be there in every citizen's mind, every citizen's heart, then we cannot achieve that fraternity. So for achieving the fraternity, it is required that this type of the feeling should be there in every Indian's mind. Then in AIMS, students versus union versus AIMS, AIMS students union versus AIMS. This was of 2001. Justice C. Lahochi of the Supreme Court. Now, this was the case regarding reservation in the postgraduate seats of the MS and MD in AIMS, and the reservation to the postgraduate students was not supported by the Constitution after this Indira Sahani judgment, that the reservation in specialty courses will not be there. So the court in this case held that the preamble, which has been assured to every citizen the idea of fraternity, which is a means to achieve the national unity and dignity, then this fraternity or the assurance of fraternity would be undermined if the reservation will be given to those which is not given or provided under the Constitution, and therefore it would be losing the values of the constitutional principles. So we see that the reservation for the specialty, super specialty courses is not given by the Supreme Court. But in 2011, you see in Indian Medical Association versus Union of India, wherein this 93rd Amendment of the Constitution, which has inserted clause 5 to Article 15, which speaks of the admission in the central institutions, central academic institutions. That was the issue in this Indian Medical Association, Article 15, Clause 5. And the court has emphasized in this case the need for providing this widespread access to the education. As I told you, that the fraternity can be enhanced and promoted by availing the public services like education, health, etc. So the court in this case emphasized on that need for providing the access to education, and when there would be greater access to the education, that would promote the ideal of the fraternity. So in this case, you see a connection or a relation was drawn between the equality rights and the fraternity. And the court was of the opinion that if there would be no equality, then the person cannot have the access to the resources of the nation, the access to the services of the nation. And when there would be no access to the services and resources of the nation, then equality would not be there. And if there would be no equality, then it would not result into fraternity, because of the social conditions, that we were not having the similar conditions. There was disruption on various grounds, particularly communal grounds, but on linguistic grounds, various grounds were there. So if these type of the inequality would remain, and there would be no access to the resources, then naturally it would not result into fraternity. So here what the court said, that Article 15 Clause 5, which speaks of the reservation for the persons of the other backward class in central academic institution, that is not violative of any of the provisions or fundamental rights. Rather, Article 15, Clause 5 is held to be the basic structure in this case. In Indian Medical Association versus Union of India 2011, which has where the challenge for 93rd Amendment, which has inserted 15 Clause 5, was Supreme Court held that this is the basic structure of the Constitution. Then there was another case, Nandini Sundar versus State of Chhattisgarh. Now, this was a case which was related to the appointment of some of the special police officers, SPOs, in order to constitute a private military, Salva Judo. You must have heard about that, Salva Judo. And the purpose was just to control the Maoist activities in the state of Chhattisgarh. That was challenged. And that was challenged on the ground of Article 14 as well as Article 21 of the Constitution. and the court held that this appointment of the SPOs is violative of Article 14 and 15, and at the same time the court has employed the idea of fraternity in this case, and the court has taken clue that there is a buffer on the unchecked state power. This is one thing, and second, that because the state has taken part in appointing these special officers, SPOs, in that manner. So, as a mechanism to promote more inclusive economic policy that is in consonance with the directive principles of the state policy, and to reinforce the center's responsibility for upholding the human rights in the nation, these type of the things are not required, and therefore the fraternity idea has been enhanced by the Supreme Court in this case, and the use of fraternity in the manner is indicative that fraternity not only binds the organs of the state but also binds all level of the states to certain constitutional limitations. That is Article 14, which speaks of the equality, and Article 21, which speaks of the personal life and personal liberty. On that basis, the Supreme Court has given this judgment in Nandini Sundar, while rejecting the appointments of the SPOs that were being taken by the state government there just in order to control the Mao activities. So you may be aware that some of the children below the age of their job, even they were being appointed to control these Maoist activities by giving them the arms and ammunitions that was held to be violative, and that was not to bring the idea of fraternity. Then in 2019, the Supreme Court in Indian Young Lawyers Association versus State of Kerala, that is also known as Sabrimala case. So here you see that discussing this object of the Indian Constitution, Supreme Court observed that preamble aims at not only the transforming of political power from the colonialism, but also the transformation of the structure of the governance. So that they want to make the individuals as the main point of the society, of a just society. And the court held that the principles of justice, liberty, equality, and fraternity, they are not disjunctive. Disjunctive means that they cannot be interpreted in isolation, they cannot be interpreted separately. They have to join together, they have to combine together in order to achieve and to fulfill the human values. And therefore, in this Sabrimala case, the Supreme Court had again held the idea of this fraternity that is required in order to bring the equality. This is a case which is related to the banning of the women from 10 to 50 years of age to enter the temple. This is also this Sabrimala case. So this fraternity on the basis of equality is important. That was the judgment of the Supreme Court in this case. So fraternity is required as an ideal. Then very recently in 2020, the Supreme Court in Prithviraj Chauhan versus Union of India, Justice S. Ravindra Bhatt delivered the judgment, and he was of the opinion that one of the objectives of the preamble to our constitution is fraternity. Fraternity, that is assuring the dignity of the individual and unity and integrity of the nation. So the court held that it will be relevant to cite the idea and the explanation which was given by Dr. Ambedkar, and what Dr. Ambedkar said about the fraternity, that the fraternity is means a sense of common brotherhood for all Indian. And this was quoted by the Supreme Court in this judgment of Prithviraj Chauhan, which was related to this reservation policy, that is relating to the reservation, this Prithviraj Chauhan case. Again, you see that the court has tried to equate this fraternity with that of the equality, and considering that India has one common citizenship and every citizen should feel that he is Indian first, irrespective of any of the basis on the ground of the social or the customary origin. And the court was of the opinion that the measure for bringing the equality should be welcome. And what are those measures to bring the equality? Naturally, the affirmative actions or the positive discrimination, so that everybody could be brought in the mainstream of the society. And this was the judgment of the Supreme Court, and it has interpreted fraternity in terms of the equality. Then another thing which is related to the fraternity is the dignity of the individual. So why it is required to promote the fraternity? That is in order to assuring the dignity of the individual. So Jawaharlal Nehru, while talking about the democracy, he was of the opinion when he said that he believes in democracy or he believes in the democratic institutions. But his basic idea was that he wanted to bring this basic factor of the dignity of the individual. And dignity can be conferred upon the individual, or dignity can be brought for the individual only when there would be opportunities for the growth, opportunities for the growth in social institutions, in political institutions, in economic institutions. So it is very important that if there would be dignity of the individual, then he must be given the opportunities for the growth, for the prosperity, for flourishing, whatever is there in all the institutions of the national life. So this was the idea of Jawaharlal Nehru about the dignity of the individual. And you see that the preamble links fraternity with the individual's dignity for the unity and integrity of the nation. So the basic reason for inclusion of this dignity was that some members of the community are treated as a lower order and they lacks the feeling of fraternity, and each one must enjoy the same status and dignity. So we see that this objective found place in the preamble in order to bring the equality. So equality being on the topmost preambular objective, that is also spreading the fraternity and dignity. And Chief Justice Sikri in Keshwanand Bharti case also held that the entire structure of the Constitution of India that was built on the basic foundation of dignity and freedom of the individual. And this we see that not only from the preamble, but the whole scheme of the Constitution that speaks about this dignity and freedom of the individual, various provisions in part third particularly speaks for that. And Justice Shellet and Justice Grover, they also spoke about various rights which have been made available to the individual citizens, like equality, religion, the dignity and individual can be dignity of the individual can be maintained. And the court held that the whole scheme which is there in the Constitution, that is just to bring about the social and economic changes without taking away the dignity of the individual. And part third and part fourth particularly, if we talk about regarding dignity, then we find that the state has to maintain, or the state has to go for its policies as a welfare state, which can be said to bring about the dignity of the individual. So maintaining dignity, it is required that the certain minimum this justiciable rights must be made available to the individual, which is you see is given under Article 32 of the Constitution. Then to ensure that the individual is free from any types of the misery in the society, or there is any want he's asking for, without which the freedoms or the idea of the self-respect and dignity are meaningless. So all these things are there in the Constitution. And you see that untouchability is abolished, titles and awards are prohibited. So these are showing that these are the things which are meant for bringing up the dignity of the individual. And you see that the Supreme Court in LIC versus CERC, this is Consumer Research Center, 1995 Supreme Court has held that right to dignity is a fundamental right. And you see there are various other judgments where the Supreme Court has interpreted Article 21, that is the right to life and personal liberty, to include the human dignity as the fundamental right, under Article 21 of the Constitution. So dignity is important, and that dignity has been tried to be maintained and to in the Constitution under various provisions by providing them equality, by providing them various liberties, by providing them the right to move to the court when there is a violation of the fundamental rights. So they can have their dignity intact by enjoying all these rights, which are the part and part third. At the same time, the livelihood rights, the equal pay for equal work, to conditions which are workable, all these provisions under 42, 43, 46 of the Constitution, they all are directed towards the maintaining of the dignity of the common man. So this assuring, promoting the fraternity, assuring the dignity of the individual, that is directed towards the unity and integrity of the nation. Now, the principle of common citizenship is directed towards the strengthening this sense of unity and integrity of the nation. And when we see this integrity, you know that integrity was not in the original Constitution. It was only inserted after 42nd Amendment to the Constitution, along with socialism and secularism. So this is the third word which has been inserted after unity and integrity of the nation. So for the founding fathers, we see the Indian Republic that the Constitution was above all an instrument for nation building. And it was the result of, we can say, a good deal of mutual accommodation, compromises, consensus, debates, discussions. So many things were there when we have this Constitution of India in our hands. So the makers of the Constitution, they realized that it was necessary to deal with the various types of the diversities which are here under the overall Indian national identity. That national interest has to be taken care with, and it has to make a nation strong. The center has to be made very, very strong. So when you see the provisions in the Constitution, though India has gone for the federal constitution or federal system of the governance, but we find that there are provisions in the Constitution which speaks for the strong centralization or a strong unitary system, and it does not remain federal in some situations which are not normal. And that was the need of that time when the Constitution was being framed, because India has seen the slavery of the Britishers. India was a colony of the Britishers, and it was only because of that the nation was not strong. So to make the nation strong, to bring the unity and integrity of the nation, this was to be put in the preamble as one of the idea, one of the objective, that India has to be united, India has to be integrated. Now, very importantly, you see that the term used, unity and integrity of nation, it is not used unity and integrity of India. What do we mean by this nation? That is again very important. And you see this in Balsamma Paul versus Cochin University. It was 1996 judgment, Balsamma Paul versus Cochin University, when the court held that we are all directed to what is strengthening the Indian fraternal feelings and building of one united nations and strong Indian fellowship. That is, we have one constitution, one flag, and one citizenship for the entire country. And we have to imbibe these things in our working also. And we see that if we are talking about the nation and not of India, so there is an emotional bond with the territory, its culture, its traditions, its common ancestors also we see. So it's the feeling of nationalism that is the unifying force to keep the citizens as one. And it lends the identity to the citizens. We are Indians. And preamble that emphasizes on the unity of national community. It is not the physical unity and integrity of the territory of India, that is confined only to the geographical boundaries that India is having. So it's not the unity and integrity of India which can be considered through its geographical boundaries, but it is the unity and integrity of the nation which is related with the culture, with the tradition, with the emotional bonds, with the common ancestors. So everyone, every citizen should feel that he is Indian first. He has to do something for his country. Then this unity and integrity would be conceived, that this unity and integrity can be achieved, which was the basic point in the constitutional preamble. So we see that anyone who says that there are more than one nation, because you see every time there are voices to divide the country. So that is a wrong concept, and that should not be there. And maybe that the idea of one nation, one election, national party or national agenda, that may bring more and more unity and integrity of the nation, because we are all witnessing that what type of the activities are going on in the nation, and these may be considered against the unity and integrity of the nation. Various terroristic activities, they are also there. So if these type of the things would remain, then naturally this idea of unity and integrity of nation would not be survived for a long time. And for survival, India has a long tradition and culture that should be continued, that would flower like anything. So we need that this idea of national party, national agenda, that may bring the unity and integrity instead of division at every place. And this is how we can see that the preamble to the Constitution of India is making a very significant part of the entire constitution. And this was also the issue whether this constitution preamble is a part of the constitution or not. So in Berubari case, Supreme Court said that this is not the part of the constitution, while in Keshwanand Bharti case, this Berubari judgment was overruled, and Supreme Court said that this is the part of the constitution. So this was something about preamble to the constitution.